My name is Aimee Kaloyares with RM Legal, and I'd like to go over what to expect when you have a family court rule date. The first question I get from the majority of my clients is, what is a rule date? And it can be on your paperwork as a rule to show cause or a rule nisi. Both of these terms refer to someone having filed something that requires a hearing before the judge, either to determine a matter or a hearing to determine contempt. And the basis of those claims will be in the rest of the paperwork that make up your pleadings. So when you come to a rule date, it may be a rule to show cause, again, for a claim like child custody, child support, interim support, or it might be for contempt for having not paid child support, interim spousal support, or for violating a custody order. Absolutely required is service on all of the parties so that they have notice to appear and can prepare for the hearing date. At this court date, it's possible that your claims might be resolved through a stipulation or a consent judgment. But if the parties are not in agreement on any particular issue, then we would not be able to enter into that agreement and a hearing would have to occur. In some of the courts, the judges utilize hearing officers. Those are mediators that the courts use at no cost to the parties to try and resolve the claims and enter into a stipulation or a consent judgment. Also, at your rule date, you might hear the attorneys request a status, which is where the attorneys will talk to the judge, kind of take the judge's temperature on what the judge may rule in a hearing, so the attorneys can go back to the parties and discuss a possible resolution based on what the court is likely to do. If nobody is in agreement on any particular issue or all the issues, and if mediation is not successful, either through the attorneys or through the mediator, then a hearing will need to take place. It's very likely, due to the volume of people who are all set for a rule date, that you will not have your hearing on this day. It's possible that your hearing will be scheduled for a separate trial date. You do want enough time to conduct what we call discovery between the parties, which is where we exchange information, witness names, and any type of evidence that might be brought up during the hearing. You do want your attorney to do this for you so that you can be prepared for the hearing and any witness or any issue of law that needs to be brought out during the hearing. It also gives you an opportunity between the rule date and the trial date to subpoena any witnesses, records, medical records, police reports, other reports, school records, things that might be important for the judge to know about your custody case or your other family law matter. The trial date will be selected by the judge's calendar. However, your attorney will come to you, and the opposing counsel will also have the opportunity to select a date so that it's a date that's comfortable for you and, again, allows enough time for any kind of discovery that needs to happen. These are very stressful days. These are very stressful issues. So I hope this video helps a little bit in preparing you for what will be your first family court date. Thank you.